Alex here with a legal nuts and bolts video on subject matter jurisdiction. Please take a look at my previous video because in that video I cover personal jurisdiction and I also cover some of the abstract big picture principles as to what jurisdiction even is. So going straight into it, I'm just going to use two examples and I'll talk about it a little bit. Subject matter jurisdiction is a question as to whether or not the court has the authority to make a decision based on the issue that has been brought before it. Unlike personal jurisdiction, which is a question as to whether or not the court has the jurisdiction to or the authority to render decisions on the people that have been brought before it or on the property that has been brought before it. So, for example, like a quiet title or something like that. Anyway, I covered that in my previous video. Going back into subject matter, I'm going to use a couple of examples to show, and they're going to be kind of obvious. I mean, everyone's heard about the small claims one. If you file a small claims case, if you file an action in a small claims court and you're trying to sue for like $20,000, you can't do that because, now most people know you can't do that because of the rules. Well, the actual formal reason is that the court doesn't have subject matter jurisdiction over the issue. The court may have jurisdiction over the person you sued, but it doesn't have jurisdiction over the issue, which is too much. It's the amount of money you want is too high. So another good example would be something ridiculous, like let's say you file like a lawsuit for money damages in a bankruptcy court. Well, the bankruptcy court may have jurisdiction over the person that you've sued because they live there, or the property because it's in their county, but they don't have jurisdiction over the issue that you've brought before it because they only have jurisdiction over subject matter jurisdiction over bankruptcy types of issues and cases. Another one might be an appellate court. So like let's say you file another ridiculous thing. Let's say you file a child custody action in an appellate court. Well, they only have jurisdiction over the decisions that lower courts have made, and they only have the jurisdiction to look at mistakes that the lower court has made. They don't have jurisdiction over kids and no. So those are just three examples of where somebody would have filed something again in the wrong court. Now, most people hear wrong court, they think you've sued somebody where they don't live or something like that, and that's what I cover in personal jurisdiction. But yeah, wrong court can apply to you've just brought the wrong topic before the court, the wrong topic, the wrong issue, the wrong subject. So if anyone has any questions, feel free to post it in the comments below. I myself personally have never had a case dismissed for a personal jurisdiction issue or a subject matter jurisdiction issue, and I think that's probably because it's so intuitive to the average person. Like, the average person knows you can't sue for 30 grand in a small claims court. They know. And the average person knows you can't try and get your custody dispute resolved by a bankruptcy judge. Most people know that without needing a lawyer to tell them. There are some weird situations where a person may not realize that a court doesn't have subject matter jurisdiction. If anyone has had that happen to them before, post in the comments below because that might be helpful to some of the people watching. One last little quirk that I looked into was that you can waive any kind of argument concerning personal jurisdiction, but you cannot waive any kind of argument concerning subject matter jurisdiction. So, for example, let's say you are in Nevada and you want to sue somebody who lives in California in your own court. So in Nevada, in the Nevada court. Well, you have, obviously you can't raise personal jurisdiction. Number one, why would you want to? It's your own state anyway. But number two, obviously you can't assert personal jurisdiction because you're the one that sued there. So I mean, that was your choice to go there. So you can't sue somebody in a court and then say, wait a minute, you don't have personal jurisdiction. Well, if that was the case, you shouldn't have sued in that court. They can try to bring that up and get the case dismissed, or they can consent to it. They can file an answer in Nevada, even though they live in California, and that effectively waives their right to come back later and say, hey, you don't have personal jurisdiction. They consented to it. The judge may have not officially had it, but now because they consented and waived the right, now the judge does have the authority over them. So the judge can get personal jurisdiction over a person who decides to, waive that argument. As I mentioned, in contrast, a judge, a court, cannot do that with subject matter jurisdiction, no matter how much you and your opponent agree. If a court does not have subject matter jurisdiction over an issue, it cannot render a decision. You have to file it in the correct court. So another good example would be, say you sued for a small claim. You sued in small claims court. Let's say you sued for 20 grand. The limit is supposed to be, we'll say 7,500. And you and your opponent say, hey, you know what, Your Honor, I know this is a small claims court, but we don't mind you resolving this issue for us, even though it's $20,000, even though it's over the limit. Well, you can't. You cannot both consent and waive that argument. If the court does not have the authority due to subject matter jurisdiction, the court cannot render that decision, period. And if you force it, anyone at any later date can say, you know what, I don't want to follow this anymore. And they literally can do that. And if the judge doesn't know, that's really a tragedy right there, because the judge may think, oh, well, these people don't mind, so I'll go ahead and render this decision. And then the loser goes, you know what, I'm not going to follow this, and I don't have to because that judge never had the authority. That's in the case law. Subject matter jurisdictional issues are no joke. In fact, in Nevada, in the Supreme Court of Nevada, you can actually, okay, so you're not allowed to assert arguments that you have not first asserted in the lower court. If you have not brought an issue to the lower court's attention first, you cannot bring it up in the Supreme Court or in any other court of appeals in Nevada. There is one exception, though, and that is subject matter jurisdiction. You can bring that up even though you didn't mention it at all in the lower court. And the reason is that the way the Supreme Court, at least in Nevada, looks at it is that you are not really trying to bring up a mistake in whatever legal issue was brought before the court. You're trying to say that that judge, they made a decision that they didn't even have the power to make. And it's so fundamental that the Supreme Court will let you bring that up for the first time on appeal. And it does happen sometimes, and it does work. But again, I mean, you don't even have to really do that. You could assert that anytime, anywhere, anytime. So just keep that in mind. I'm sure it's not going to be a really huge issue for a lot of the people on this channel, but if it ever was, that would be interesting to see in the comments below. And with that, I'll go ahead and end this video.